Peace, everyone. Welcome to our Moroccan Post, Moroccan Post Law, History, and Government class. This is a live Zoom recording, live Zoom class. The recording will be available tomorrow. This is September 28th, 2022. All right, this is the Moorish relations, Moorish treaty protection and consular relations, part 5, class 6, consular notification. So the focus tonight will be consular notification. We have several readings tonight, and so Shem Malachi Bey is going to elaborate on the readings. So we have the Moroccan Post Media YouTube page, the Moroccan Post Media YouTube page. We have all the classes are uploaded on those pages. The Moorish treaty protection and consular relations series is on the Moroccan Post Media YouTube page. We also have the Moorish body politic formation course class, 12 classes on the Moroccan Post Media YouTube page. Also, you have my books, Moors and Masonry, Part 1, Masonic Conference Square and the Connection of Timekeeping and Measurement, Illuminati, Illumination of the Mind, How Moon and Venus Rule, and Moors and Masonry Part 2 coming your way soon. Moors and Masonry Part 2 coming your way soon. We also have etymology and vocabulary, supplementary 1. Go to moorsandmasonry.org, moorsandmasonry.org. I'm excited about today's class. I spent 2 or 3 hours preparing stuff Shem sent me. I had to read through it and prepare and structure it for the curriculum for today. All right, so definitely, before we get started, I want to explain is the word foreign, because we'll see the word foreign in some of the texts that we read, and because we must be clear that foreign doesn't mean distance. When we say foreign, China, like distant land, distant land, we think we equate the word foreign to distant land, China, France, distant land. That is the wrong concept. That is the wrong concept to associate foreign to distance. Foreign relates to jurisdiction. It's very important. Foreign relates to jurisdiction. So you say, well, Abdullah, well, how could I be a foreign national at my job? We're on our own land. How can I be a foreign national on my job? We're on our own land. Well, yeah, you're a foreign national to your job. Let me explain. On the Moroccan Post, on the Crumb TV YouTube page, we have the 3-part series of Recovery of Lost Moorish Sovereignty. The Recovery of Lost Moorish Sovereignty, Part 1, 2, and 3. Are they on the Moroccan Post Media YouTube page? But they're on the Crumb TV YouTube page. The Recovery of Lost Moorish Sovereignty, I think, is the Power of Moorish Treaties and Recovery of Lost Moorish Sovereignty, Part 1, 2, and 3. It's very important that you watch those so that you can get an in-depth understanding of foreign. All right. Now, though, when you see a map, if you Google a world map, you'll see names of those maps. How did that come about? How did the different names, China, France, England, Germany, United States, how did it come about? We must keep in mind European land boundary cession treaties. France, Sweden, Portugal, Spain, England / Great Britain, the Netherlands, the extension of the child of Great Britain, United States. We must keep these in mind and keep the treaties, the various treaties of land boundary cession treaties. There are surveys done. So what you have on our, yes, this is our land, but we must be cognizant because of those European boundary cession treaties and surveys that Spain and France and Great Britain, and particularly Portugal and Spain, Portugal, Spain, and France, because Great Britain, France being the occupying predecessor, the European occupying predecessor state before Great Britain, you know, and then so Great Britain, that 1763 war between Great Britain and France, Great Britain takes over the land that our Moorish took. Great Britain now extended her territorial sovereignty, where France lost the exercise her territorial sovereignty of our land, and that was ceded through the 1763 peace treaty between Great Britain and France in 1763. I'm just giving you an example. In that treaty are the land boundary that was ceded to Great Britain. Ute posteditis juris. That's a term in international law. Ute, UTI, posteditis juris, whereby the secession state takes over the land boundaries of the predecessor state under Ute posteditis juris. So France set up more survey boundaries that Great Britain took over. So these are surveys that were done and survey maps. As a result of that, created zones, French zones, Portuguese zones, Spanish zones, English zones, Swedish zones on our land. So yes, we are on our land, but we got to be cognizant of the Inter Caetera Divina of March 4th, 1493, of European colonization, and these France and Spain and Portugal, England and Netherlands and Sweden are fighting over our land, and they, so they're taking control, and so there's zones. So this is how I'm explaining how you're a foreign national on your job, which it would be in a British zone or Spanish zone or French zone, all right? And that's so I'm saying Spanish zone because Spain still has the occupying sovereign authority over what they call Texas and Utah and Nevada and Colorado and Mexico and New Mexico and Colorado, and Spain still has the occupying sovereign jurisdiction. So this is very important. This is why we did the Power of Moorish Treaties and the Recovery of Lost Moorish Sovereignty on Crumb TV, part 1, 2, and 3. We have to understand this. We must be able to address this intellectually by being aware of what's going on. We cannot be blindsided. So we must understand that there are zones, French zones, Spanish zones, Portuguese zones, English zones, as a result of these land boundary treaties and surveys and survey maps. Survey companies were hired to do surveys. So when you see these maps have changed over the course of years based on wars and land boundary cession treaties. So where predecessor state, cedes to the succession state. So those are not the name of the land masses that you see on maps. Those are the names of the state, the current state, political state that's exercising her territorial sovereignty. We must be able to articulate it in this manner and come to understand it in this manner. All right. So I wanted to break this down so that we will understand foreign relates to jurisdiction. It's very important. We've got to raise y'all up. We got to rise to another level. We got to take on to another level. All right. So we're gonna start with hey, Viserious, are you on? You and Amanda will share the reading. Is Viserious on? If not, Amanda will start with you until Viserious comes on. All right, so Terrence, you have that up, page. We're starting with page 182, page 182. So we're starting with the federal criminal prosecution and the right to consular notification under Article 36 of the Vienna Convention, page 182. I don't think that's the right art. Is that, oh, yes, it. There we go. This is it. All right. So this is, once again, this is a federal criminal prosecution. And Terrence, can you go, Terrence, before we go to the title page? I want the title page to be shown on the video. Go to the title page. If it's too much, don't worry about it. If it's too much to go to the title page, yeah, so show them the title page. It's important that because we got people who are watching this on video. So this is the title page. All right. West Virginia University, the research repository. All right, September 2nd, 2002, federal criminal prosecutions and the right to consular notification under Article 36 of the Vienna Convention, so that we can understand, we can see the author, all right, and Department of the Interior. So this is actually this person. This is Roberto Iraola. Department of the Interior. That's the United States Department of the Interior. All right, so we're gonna go right down to page 182, and Amanda, you'll start. All right, we have consular relations and the Vienna Convention, and I'll stop you where, and so then Shim will explain, will elaborate on some points.
Consular relations and the Vienna Convention, protecting nationals through the auspices of consular personnel, is an ancient tradition recognized as fundamental to international law. In 1963, existing international law on consular relations was codified by 92 nations by adopting the multilateral treaty of the Vienna Convention. Can you scroll up?
Roll up, I'm Terrence. Got to roll it up.
Oh, really? Oh. So where?
All right.
Can you see
Got to
it?
go to the next page.
Oh, really? Okay. Sorry.
All right. Yeah, all right.
In 1969, the 79 Article Treaty was ratified by the United States. The delay stemmed from concern over whether, given that the treaty met only minimum standards for rules governing consular relations, the United States should instead continue negotiating bilateral agreements. Eventually, however, ratification of the treaty was sought because the Nixon administration believed the agreements continued an important contribution to the development and codification of international law and should contribute to the orderly and effective conduct of consular relations between states. To date, the Vienna Convention has been ratified by 160 countries. Further, it has been noted that because of the difference in political and economic systems represented at the meeting, the Vienna Convention is considered the most expansive agreement on the subject of consular relations. The State Department had stated that Article 30, is it Article 30? Obligations are
36.
36 are of the highest order and should not be dealt with lightly. Article 36 of the Vienna Convention. The Vienna Convention recognizes that to facilitate the exercise of consular functions, communication with the nationals of the sending state is essential. To that end, Article 36, subsection 1, subsection A, provides that consular officers shall be free to communicate with nationals of the sending state and to have access to them. Conversely, nationals of the sending state shall have the same freedom with respect to communication with and access to consular officers of the sending state. One important consular protection concerns acquaintance to a foreign national who has been arrested abroad. A key provision of Article 36.
That was assistance.
Assistance, sorry. One important consular protection concerns assistance to a foreign national who has been arrested abroad. A key provision of Article 36 obligates the receiving state to notify the national of a sending state who has been arrested, placed in custody, or otherwise detained, that he has the right to have his consul notified without delay of such arrest or detention. Specifically, Article 36, subsection 1, subsection B states, if he so requests, the competent authorities of the receiving state shall, without delay, inform the consular post of the sending state if, within its consular district, a national of that state is arrested or committed to prison or to custody pending trial or is detained in any other manner. Any communication addressed to the consular post by the person accused in prison, custody, or detention shall also be forwarded by the said authorities without delay. The said authorities shall inform the person concerned without delay of his rights under this subparagraph. The State Department has interpreted this provision to require notification to the foreign national as soon as reasonably possible under the circumstances and suggested that officials comply with this requirement where the arrest is followed by detention by notifying the foreign national.
Shem, we're gonna stop you there for a minute. We're gonna stop you there, Amanda. Shem?
Yes.
All right.
Anybody any questions concerning it?
Any questions? Any questions on what was read?
So this is Brother Rosarius. So basically, what it's saying is that anytime that someone or more, whatever the case may be, is arrested or detained, they must notify the consul without delay. So that means immediately, I'm assuming. And my next part of that question is, it's supposed to be everything. They're supposed to let the authorities, whoever know that contacts the consul, everything that's in that second part.
By serious, we're gonna instead of using a pronoun, use a noun. Use a proper noun instead of a pronoun.
Okay, so
Yeah, you just use substitute the pronoun they with a proper noun.
okay, so the governing state.
Identify the jurisdiction by name. Identify the jurisdiction by name.
Okay, so State of Arizona Corporation. detains a Moorish national. In detaining him, they have to notify council, it says without delay. So I'm assuming that's immediately they must notify the council. How would they have the council number?
Okay, let's answer that. Now let's go by what's going on every day and people having affiliation with law enforcement officers. If I'm from Pennsylvania and the cop stopped me in South Carolina, right? Now,
Right.
this happens. The first thing that we pull me over, the first thing they look at is a tag of the car of a walking. He asked me to identify myself. Now, I give him a card or a passport, whatever it may be. The moment that I give him that, that's showing him that I'm a United States citizen. I'm gonna take that on the Constitution, and I'm also affiliated with one of the states of the Union. Now, when he questioned me, the first thing he had to do, based on court policy, the Supreme Court hands down decisions, which are called private court policy, direct the lower state agencies in enforcing the Constitution and protecting one's rights, a United States citizen right. He's supposed to give you your Sixth Amendment warnings, your right to counsel, and Fifth Amendment, and then you have right to remain silent, and then you say you're held against in the court of law. Now, that is self-determined based on the reading of the amendment of the Constitution. Now, this convention was ratified, consent to by Congress, signed by the president, ratified by Congress. It acts as a customary law as if it's a legislative act passed by the federal government itself, a statute or code. So therefore, when you get locked up, he don't say anything. It's your job to say, hey, listen, when you show him the ID, I'm a Moor. I'm of this government. Automatically, he's trained. The context of a supervisor or head commander is I got a foreign national here that got a treaty in the United States. They have to give you counsel judge instruction right there. Or they ask you where your counsel located at. So I advise every government national traveling to foreign jurisdiction have a card with the council number on everything. So that way, that's government relations. I mean, your government already have a standing relationship with that government. How you mean? There's an organization that government has that enforces international law. So your counselor gives notification, the counselor, the head of the government, executive power of your government, sends a notice to the secretary, the State Department of Foreign Affairs, that he resides in the territory of Georgia. That's a counselor facility operating in the United States, designated in a territory, territory political jurisdiction of Georgia. Now, once you notify that council takes jurisdiction. It's under the council's jurisdiction. The council comes out and discusses all the transcripts, testimony, witness, proof of claim, affidavits, probable cause go through the council jurisdiction. The council is the only one to make the determination of the guilt or innocent in that matter. You understand?
So how will we, so that council, is that is our council active now?
All right,
Like,
let me answer that, Shem. All right. That's something you would have to, that's something that you have to facilitate by Sirius. You would have you in setting up a study group, not government. Don't start with setting government up. Set up a study group. All right. Educate the people. That's what you're here. And you've been doing that. You've been sending it out to many people. You're well connected. All right. You're doing it. You're already doing it. So I don't have to tell you what to do because you're already doing it. You've been doing it for years. You've been out there for 12 years. You've been out there for over 12 years and you've been reaching out to many people. So you're already doing it. All right.
okay.
So as you continue to learn in these classes, you'll be able to, with our guidance, to facilitate Moorish government structure, because you already have a network. You already have connections. It's just now taking it to another level to facilitate Moorish government structure. That's why you're on these classes. So I'm saying you're there. I mean, you already know what to do because you already have a network, a connection to people already. A lot of people know you where you are and outside of where you are. You know, I've known you for 12 years. You already, so this is why we're having these classes, but that's something that you would have to facilitate with our guidance in studying, facilitating Moorish government structure.
Got you.
I want to be, articulate. I know, yeah, with
You want to
clarity.
be articulate? You know me for 18 years, brother.
My 18 years,
Actually, 20. I
20.
met you in
Let's be
02.
correct. So I want to be factual. All right. Any other questions? Any other questions? Brother Michael, can you elect? Michael, can you talk about your experience? Michael, can you talk about your body politic? Can you help us in explaining what you did to establish your Moorish body politic and how and your experience and functioning as a Moorish consul?
Is Mike on?
Peace, love, boss. Yeah.
That's all, Mike.
First step one. Step one is attend the classes. Study, did my own research to make sure that everything that was being conveyed to me and my members, that everything was obviously provable, and that was the case. So after we did that, we just we created a government body politic called the Divine Envoy for Yahweh, which is an ecclesiastical Moorish Moroccan state, and we just started recruiting members. Some of them was people that was on this journey with us, and others were just people that just took an interest and been on this quest with like ourselves, and we just formed our body, and we're still like some once or twice a week we get members that want to join. So with that said, you need you need numbers. You need numbers. You got to do your elections, because the best way to do it is to obviously you can't have saying so many chiefs and not enough Indians. It's good to have members, but in facilitating the best step-by-step structure to building your body of politic, I would start by building from the top down, meaning, based on what you're qualified for, what is people's background, what's their special interests, as opposed to just building members, because it's good to have members that you can study with, but if someone gets jammed up, you're kind of counterproductive, with, facilitating that cause, getting, mad as dismissed and, helping your nationals. So we thought it would be best to just, build it from the ground up. Akeem is another member here in the study class, but he's one that I've been on this journey with for 10 years. Himself, myself, and another brother named Brandon. We pretty much formed it and we started recruiting. And like I said, we've already did our elections for our consul and head of state. And like I said, we're still building. So we have, our naturalization papers, we have our legal ethnicity papers, and that's what we give to all of our nationals as part of us. So in the event, something happens, we have our 1-800 number, we have our website, we have our state email, everything we have, and we actually we registered an account with the United Nations, our profile with the United Nations, and we are in the process of actually getting our identifications registered with the Department of Homeland as well as the Department of State. So we're going through those channels to get that in the federal registry. Now, so kind of like we're going as we've been going along, it seems like the courses just recognize competency and they respect intellect as opposed to not. And we come in this structure where we're exercising consular jurisdiction and utilizing the treaties and utilizing it properly, putting the right paperwork in, and removing it to where it needs to be. The rest is history. That's pretty much what happened. Once you do that, they have to respect that because they're under treaty obligation. So really, it's just structure. A lot of times, what I think the issue is that a lot of people are looking for in the class is they're looking for how they can go ahead now and get victory going on their own accord. basically that looks like a sovereign. With that, even exercising a treaty, you might as well come, with a United States sovereign citizen process, because that's not well settled based on governmental structure. Who's the point of command? It's just how that works. When a United States citizen gets pulled over or gets detained, at some point, if not soon enough, before any question or any interrogation, where they say, "I want an attorney." So, as it will relate to a Moor, it would be, hey, I'm protected by treaty law. Okay, my ancestors or my foremothers and forefathers have a treaty with the European nations, Great Britain, Spain, France, Germany, etc., United States. Pursuant to this and this, I have a right to counsel. So when you start exercising that, that competency, and actually have a counsel, to actually contact, then it's plausible. So you don't want to give them any type of way to get at you, and use plausible deniability. So that's what you got to do first. I was listening to the brother from Vicarious. I was listening to him. Yeah, you asked if there's a counsel in place. In your particular case, no. But I recommend that you follow our footsteps that we did, and get start getting your guys together.
Yeah, he's doing it.
I'm sorry.
He's doing it. He's doing it. He's
Okay.
following us.
Yeah,
He's
yeah.
doing it.
And guys, just the FYI, we're not, it's 20, 30, 40, 50 minutes. That's not what we're trying to, if that's what you have to start with, but now you can actually get people in positions to where you actually have your elections, and you can actually have that documented to where now you can start reaching out to these agencies and putting it on a record of who you are. Then by all means, that is a starting point, because like I said, we've been be able to get victory that way. But of course, you still want to grow your population. But if you got 20 or 30, 40, let's say you got 10 people in positions of, you have 10, foreign officials, the vice consuls, consular generals, your head of states, saying you have some minister of foreign affairs, and, however you're going to structure that. Just make sure you have those positions. I would say, if you're going to exercise consular jurisdiction, make sure that you are going to have those positions in place first. Because again, I repeat, you can't have, it's good for someone to know their nationality. It's good for someone to want to be a part of something, but everybody want to be a part of something. Everybody wants to be a part of something. But you want people with, some type of intelligence, with some type of background, with even if it's just as simple as knowing the proper structure and what to pretty much submit to the court, to for whatever the case may be, that you need, and that's pretty much it. So in our cases, I've had criminal cases, I've had civil cases for my nationals have taken on cases now, and we're gonna use the same function as consular jurisdiction. Hey, my nationals are defendant in the matter. Well, pursuant to the treaty, you don't have jurisdiction. So I need to showcase that. I, as this consul, I'm the sole judicial officer. That's pursuant to the treaty. Now that's something that the courts can actually identify. That's something that they cannot refute. So therefore, it's, they gotta go ahead and comply. Simple.
Let me this is why these classes are important. So it's not just numbers, but an educated population. Particularly the officials. I've been 29 years. I've seen a bunch of empty shells. I said this, we cannot have empty shells. Abdullah, what is an empty shell? That means that you have people in positions who do not have knowledge. That's their empty shells. This is why we made this class free and made it available and uploading it onto the YouTube page, and other people have been sharing it, so tens of thousands of people can have access to the class. We also have the Moorish body politics formation classes, 12 of them on the Moroccan Post Media. Each class is 1 hour of presentation, 1 hour of PowerPoint presentation, and 1 hour of question and answer. session. I suggest that those who are by serious and others, that they take or be part of these classes, as well as the Moorish body politic formation classes. It's important. This is why we have structured curriculum, structured lessons, because by my 25, 20, I was a tutor, so 35 years. Go back 35 years, going back to college, that students learn best through structure learning. This is 35 years on hands-on experience. This is why Shem and I spent past 3.5 years of building curriculum. 3.5 years, class after class. Students, people learn best through structure learning. They would have to study. And not only, and I said particularly officials, let me scratch that. The population needs to study, not just the officials, elected officials. The population, we need an educated population of voters, a educated population of Moorish voters. So I want to make sure I'm clear. So any other questions before Amanda, Vice Serious, you want to take over the reading? I mean, not Vice Serious, yeah, Vice Serious, you want to take over the reading?
Yeah, I'll do a little bit, brother.
All right, go ahead.
Still hit the screen.
Where's the screen, Terrence?
I was getting it together. Can you see it?
Yeah, I got it. The State Department has interpreted this provision to require notification to the foreign national as soon as reasonably possible under the circumstances, and suggested that officials comply with this requirement where the arrest is followed by detention by notifying the foreign national. Where we at? You want me to read 20? Okay. Of his right.
Go to the next page. Go to the next page, Terrence.
Of his right to consular, of his right to consular notification before he is booked. If the person arrested or otherwise detained has requested consular notification, the State Department has further opined that within 24 hours and certainly 72 hours, notification must be provided. Nothing in the provision of Article 36 confer on a foreign national the right to speak with consular representative before government agents commence an interrogation, nor to delay an interrogation if the foreign national requests that consul be notified of the arrest. With respect to the right of consular officers to visit, correspond, and converse with a national who has been arrested, placed in custody, or is otherwise detained, Article 36, 1C provides, consular officers shall have the right to visit a national of the sending state who is in prison, custody, of detention, to converse and correspond with him and to arrange for his legal representation. They shall also have the right to visit any national of the sending state who is in prison, custody, or detention in their district in pursuance of a judgment. Nevertheless, consular officers shall refrain from taking action on behalf of a national who is in prison, custody, or detention if he expressly opposes such action.
What's going on?
Now I got it. Finally, Article 36(2) provides that the rights set forth under the first paragraph shall be exercised in conformity with the laws and regulations of the receiving state, subject to the proviso, however, that the said laws and regulations must enable full effect to be given to the purposes for which the rights accorded under this article are intended. While this subparagraph provides in part that the laws of the receiving state must allow for these rights to be given full effect, it has been suggested that the intention of this subparagraph seems to be to ensure that the domestic criminal procedures of the receiving state are interfered with to the least extent possible. Part 4, Department of Justice Regulations and Department of State. Advice relating to the consular notification provision of the Vienna Convention to ensure compliance with the consular notification provision of Article 36 of the Vienna Convention. The Department of Justice issued regulations to the same effect, specifically 28 CFR subsection 50.5 states in relevant part A. This statement is designed to establish a uniform procedure for consular notification where nationals of foreign countries are arrested by officers of this department on charges of criminal violations. It conforms to practice under international law and in particular implements obligations undertaken by the United States pursuant to treaties with respect to the arrest and detention of foreign nationals. Some of the treaties obligate the United States to notify the consular official only upon the demand or request of the arrested foreign national. On the other hand, some of the treaties require notifying the consul of the arrest of a foreign national, whether or not the arrested person requests such notification. In every case in which a foreign national is arrested, the arresting officer shall inform the foreign national that his consul will be advised of his arrest unless he does not wish such notification to be given. If the foreign national does not wish to have his consul notified, the arresting officer shall also inform him that in the event there is a treaty in force between the United States and his country, which requires such notification, his consul, his consul must be notified regardless of his wishes. And if such is the, keep moving up. And if such is the case, he will be advised of such notification by the U.S. attorney. 2, in all cases, including these, where the foreign national has stated that he does not wish his consul to be notified, the local office of the Federal Bureau of Investigations or the local marshal's office, as the case may be, shall inform the nearest U.S. attorney of the arrest and of the arrested person's wishes regarding consular notification.
You want to go and talk on the United States Department of Justice, Office of International Affairs. United States Department of Justice, Office of International Affairs. And
Okay, give me a minute. Give me a
Office
minute.
of International Judicial Assistance. I'm sorry, United States Justice Department's Office of International Judicial Assistance.
Yes.
Hey, give him a minute. Okay.
Give me a minute. Give me 1 minute.
No, just talk on that, Shem. Because we
I
don't want
am,
any.
man. Give me a minute.
We don't
Give me a
want.
minute. Right there.
All right, I got to talk to him because we don't want to have any delay. All right, so he's going to be looking up. This is the Office of International Judicial Assistance in the United States. The United States Department of Justice Office of International Judicial Assistance has been delegated. Based on the United Nations Office, United Nations Hague Convention of Letterogatory. So we're going to there's United Nations Hague Convention of Letterogatory for judicial assistance. Right. So the United States is signatory to that Hague Convention of Letterogatory for judicial assistance. So the United States Congress legislated for the Office of Judicial Assistance to handle that matter based on the Hague Convention of Letterogatory. So United States Congress legislated on how to implement. So when a country signs on to a convention, which is a multilateral treaty, the Hague Convention of the Letterogatory is a multilateral convention, a multilateral treaty. It's known as a convention. Their particular parliament or Congress has to legislate how to implement based on, meaning that the implementation is already set in the convention. So the Congress of a particular nation that signs on to that convention legislates, an office, i.e. for the United States is the office, United States Department of Justice and the Office of Judicial Affairs. All right, so go ahead, Shem.
Yes. Professor Abdul is exactly right. In order to implement these conventions, treaties, and declarations that the United States signed on to and ratified, they created the Senate, certain senators becomes a committee. On that committee, they pass all the rules, regulations.
Hold on, Shem. That is the Senate Committee
on Foreign Relations.
on Foreign Relations. That's United States Senate. We want them to know their names. United States Senate Committee on Foreign Relations.
Okay. Now the senators passed a law that will govern the United States as if they passed a legislative act or statute or code. Now, what goes on is that in the State Department, this Congress has set up an organization they call the Central Authority. Their job is to hear all matters dealing with letters of derogatory, dealing with criminal and civil disputes between foreign nationals that's have a civil dispute or criminal dispute in the United States political territory. And what happens is that the council, the government, the foreign government gives notification to the Department of State that is a council house or council office operating in that territory, one of the states. And by that, the council get notification, not the council, the head of the state get notification and get a council that's been appointed with delegation of authority to hear the matters, and the whole staff, all representatives, gives automatic diplomatic immunity. On diplomatic immunity on a foreign law. They got the house, the wife, the child, all diplomatic immunity and protect under national law. Called impound. It's an office the council operates as in territory of the foreign government, the receiving state. What happens is the council the council, the head of state send notification of where the council is at. So when the dispute happens, the central authority will automatically contact the council. Will notify the council notify the central authority through a letter derogatory and that all evidence and testimony concerning that national is to be protected by the treaty or international convention. Now, let me say something. When that happens, the court loses jurisdiction. It gets removed automatically out of the court into the central authority, which is in the Justice Department agency. All of it consolidated together. The Justice Department, Interpol, the central authority, all of them in the same unit. That's called diplomatic relationship. You go in the federal court. The courts don't have authority. They would not give. The federal courts are not given authority to hear any case. The only way the federal courts can hear a case is the United States become a party, and that case is recommended back into the United States jurisdiction, and it goes to the Supreme Court, making a rule based on international law. But any intergovernment tribunal is the act. Let me get this right. 28 U.S. 1782, where Congress passed an act or a statute to protect international tribunal decisions. So what it comes down to is that the federal courts have jurisdiction over more. I'm not talking about an Indian, a Negro, a Black person, or Afro-American citizen. No, I'm talking about a Moor. I'm talking about the treaty. The treaty don't say, the United States Supreme Court have jurisdiction over a Mexican. You know why? Because a Mexican comes over here through immigration. So that's why you hear the word non-immigrant, non-citizen, non-resident. What that means? It's an alien, a foreign alien, national, a foreign state, a foreign jurisdiction. They're not an immigrant. They're not a citizen, not a resident of the state. So therefore, they're alien. They're not bound by the laws of the state or the United States. They're bound by treaty law. So therefore, the treaty, the only thing comes in. So when you go to the treaty, there's no stipulation in the treaty that the United States agreed upon and the president signed that said that any dispute happened between the Moor, that the Moor could go to the federal court. No, they didn't say that. They said a council. Council meaning an international judicial officer of the state, of the hosting state. That's what it means, of the national state he's from. He's the only, that's the judicial officer. Matter of fact, I'm gonna sum it up in a master word. The 1856 treaty between Great Britain and Morocco, this is very clear. They forced the ancient law here. Great Britain knew the standard customs of this common principle, this common jurisprudence principle, that the council has jurisdiction and that the receiving state don't all the time have jurisdiction. It only goes by the basis of the treaty. Who's the hosting nation? Morocco. Therefore, Morocco is giving up the amnesty and asylum to a foreign power in his land. Therefore, Morocco is not bound by a foreign power laws in his own land. Now, see, this is very important. We talk about land and political jurisdiction. So the difference here. When you go into a political jurisdiction, you are in another territory. That's why they call it territory dominion. You're not territory.
Hold on, Shem. Hold on. Let's specify clarity. They would not be, all right, let's specify clarity. They would not be in another territory. All right, let's go back again. All right. Because I want them to, once again, that when I started off by explaining foreign. And if you want the furthermore information, you go to Crumb TV YouTube page and you look up the Recovery of Lost Moorish Sovereignty, Part 1, 2, and 3. All right, Terrence and I laid out. Now, when you see these various maps, all right, China, France, England, or in this case, New Jersey, North Carolina, South Carolina, Virginia, Maryland, all right, those are not names of land masses. All right, so when you, all right, if you were to travel on Moorish land, all right, and you leave the political zone that is, all right, so let's say you have New York is not a landmass. The political zone or survey for New York colony is in the colony charter. King Charles II, I just want to be detailed. King Charles II of England in 1662, granted a charter to his brother, Duke of York. And in that colony charter outlines a survey or boundaries of the boundary of operation for New York colony. New York State and New York colony are not the same. New York State, on the 1783 Treaty of Paris, the definitive peace treaty between Great Britain and United States, 1783. The New York State, all right, took over the Unte Postadistis. New York State took over the surveying land boundary of the colony of New York. Colony of New York. So when a Moor is traveling on Moorish land, all right, going from that on that Moorish land, and then there is the political zone, all right, that was the political zone created by Great Britain, not United States. The political zone, all right, of New York, New Jersey, New York and New Jersey, political zone created by Great Britain through the charters, right? When a Moor is traveling on his land and moving from the political zone of New Jersey to New York, they're not going to a new territory. There's no change in territory. All right. So you're still on Moorish soil. You're still in the Moorish territory.
Absolutely.
So nothing changed with that. What's the thing is that you're going to a different political zone based on the royal charters. New York, New Jersey charter, all right, and New York charter. This is in play today, my brothers and sisters. The definitive peace treaty between Great Britain and the United States, 1783. We must be aware, we must be able to articulate with clarity what's going on.
Yes. So thank you, Professor Abdul. Because what we're saying is that you're always going to be in Morocco. That's the whole C nation. The receiving nation are those that was allowed through treaty to operate as among themselves. I mean, they're allowed to function as a political body, organization in Morocco by drawing up a political zone, which is called a region or a province in Morocco. And therefore, they get them the political legislative power to govern among themselves. The king's allowed to do that when they put all their subjects over here. So right now, if I leave my house, Morocco is land, soil, water, air. You got architects that comes and want to build. So in a political jurisdiction of that receiving state or nation, they go to that nation to get a license to build there. Once they build an erection on the land or put a pavement over the top of the dirt, that's a foreign jurisdiction on your land. The house is a foreign jurisdiction. The restaurant, the franchise, anywhere you're going to, the foreign jurisdiction. Why? It's licensed in a foreign state, the receiving state. Therefore, you step into a foreign jurisdiction. That's why you're protected. Under international law, you're protected. Because you own your land, but you own what you call a shelf, which is connected to your land. Concrete, fortress streets, asphalt, beams, columns. They built on top of your land, buildings. Yes, that's a shelf. Look up the word, definitely the word shelf in international law. The word shelf. So what's happening is that the agency is set up. See, the council gives, another council, the head of the government gives notification to the head of that government that the council is going to be operating in a specific political a political region of that political organization. That means going to be domiciled in a house or a building. And what happens is the council gets notified in that jurisdiction, political jurisdiction that they house that. The notice got to be given by the head of the state. the executive power of that government. Now, once that's done, they can notify the council. See, we have to have diplomatic relationship. We haven't had that. Like Professor Abdullah say, oh, over a long time. We haven't domiciled. We have not had no Moroccan government up running, doing diplomatic relationship. We haven't had no one educated in philosophies of our ancestors and ancient law, common law. We have not been down with that. So make sure we got no bad concepts. Government is not for government don't protect individuals. Government protect the whole community as a mass, the whole society. That's what government created, to protect the society. Among that society, in that community, there's trained, educated men and women that campaign to fill certain seats based on their constitution, which is the mother of the creature, of the government. Now, the people is the one who give delegation authority to any officer or agent. Now, when our agents receive delegation authority, the agent got power to appoint someone in office to educate and train them to operate that function, this very function of that government, protect the people when they're abroad in foreign jurisdiction, not overseas. You don't have to be overseas. No, foreign. I mean, this going into a different border, crossing a line. Once a political organization is established and it got boundaries drawn up through successive treaties that was agreed upon by the receiving hosting nation, given to the receiving nation. Once you cross that boundary, like crossing a port, yes, that's a foreign jurisdiction, the boundary line, not crossing water far away. Very important, we must know that. So if a national is arrested, the national can ask for the council, he have a right to ask, or the receiving state still is mandatory. Once we see that there's a foreign national, to what? To the identity card or the passport. Once he see that, automatically he got to properly notify the council officer in the nearest port in that political jurisdiction of that receiving state. Now, once this is positive law right here I'm talking about. True concepts. No one, the treaty does not, you read that convention, it does not give no other nation course, power to hear the matter. It's a council, it's based on council. A treaty is a self-executed agreement. Once the treaty designates council, it does not say the foreign national should have a right to claim exemption under our Constitution, and we appoint him a representative or assistant. It does not say that. When it does not read that, it does not exist. So we don't got no business going on further. Now, I'm gonna say something, because I had it said to me one time. Somebody said, well, Shem, the United States Constitution said the United States got power to regulate commerce with the Indian. I said, Indian is not a Moor. The Indian is not a Moorish treaty. So that's not a Moor. They got to do with Moors. The word Indian, it don't say Moor. And the Moorish treaty doesn't say Mexican, Indian, or nothing else. Doesn't say the United States can regulate commerce on behalf of the Moors. So if it's not in the treaty, it's not self-educated. That's where the council, educated council comes in to force the treaty. And the council, I'm the only one who have a right to adjudicate this matter. As a matter of fact, I'm gonna give back to Great Britain. Great Britain understood this principle based on what? Ancient civilizations of Egypt, Greece, Phoenicia, Persia, Babylon, all of them had this principle is what? That if their nationals in a foreign country, they have a right, the officer of that government, foreign officer have a right to adjudicate that matter. That way the national rights can be protected. His rights is protected. If it's in the empire of any of the governments, they're the hosting nation. So you can't try by your laws, they got to try the laws of the empire. Whatever law the empire choose to protect them, that law applies. I got a paper that go all the way back ancient. That's the ancient principle. That's not new that they came away. They practice the old ancient common law, principle law, positive law. Positive law, negative law, you being denied culture. So a lot of us, for a lot of years, we've been taught on false and wrong concepts that we go to the federal court, but the treaty doesn't say that. The Constitution does not say anything about a Moor. So we have to be real about this. When the Moors sat down and did business with foreign governments, they used the title Moorish, Moroccan, or Moor. That's self-explanatory. So in the Constitution, it said the United States got power to regulate commerce with the Indians. Who's the Indians? Capture native Moors who they changed their identity and stole their birthright. Therefore, they got legislative power over them. They got legislative power to do contract with them, and they can write about their land and their protection based on what? The grammar, the false grammar. Man, by putting them in there, and they can't recognize. No, we not that. No. So it's very important that you understand the word. France is doing business in the United States, communicate diplomatically. France used the word native Moor. They use the word Moroccan. They never use the word Indian. They never use the word Mexican. They never use the word Latino or Spanish. They say native Moor. France knew that because France signed treaties with the native people of this land hundreds of years ago, and it was not Indians, Mexicans, or Spanish. There was Moors. That's why they use the word native Moors. That's very important. Look how France is writing in the United States. You got to understand why France made that comment, made that statement. In order to submit their sovereignty as a conquest principal nation, submit it that way. They say we want to submit this. You got to say you signed a treaty with the people that's not in servitude. The Moors is not in servitude to anyone. Therefore, they said native Moors. That's very important. The Constitution does not give the United States power to hear a case of a Moor. No, they don't. Not even the treaty. The treaty is a legislative act that Congress ratified. It doesn't say that they can sit that a council. And the laws the laws are already printed in the treaty. The articles are the laws. There are judgments There are judgments against the receiving government and the hosting government. Because both of them can sit to it. When you consent to a stipulation of article in a treaty or agreement, they become judgments, liabilities, mandatory force against you if you violate or breach them. It's very important in contract law. Any more questions?
All right, Shem, yes. I saw your hand, Akeem. I saw your hand, Ayan. All right, but I didn't want to cut Shem. He was flowing. It's very important that we let him flow because he's providing very detailed. Because of the 100-year plus a misconception, 100-year plus a misconception. It's very important that Shem, was able to explain this uninterruptedly. All right, Akeem, what say ye?
Good evening, peace and love, everyone. I just had a question about the definitive peace treaty between Great Britain and the United States. I just wanted to know if one of you brothers could elaborate on that clause in the first article that talks about relinquishing all claims to the government propriety and territorial rights. You can maybe just elaborate on the term relinquished and what exactly was given up.
I'll start with that. All right. In the 1763 treaty, definitive peace treaty between France and Great Britain. I'm not off the subject. What I'm doing is using a treaty that has the word seed in it. So as the people can understand that there's a difference between the word seed and relinquish. The word seed, SCEDE, is in the 1763 treaty between France and Great Britain. Not relinquish, seed. So you have two sovereigns, the King of France and the King of England / Great Britain, negotiating this peace treaty in 1762 was when it was negotiated, all right? And then signed and ratified, signed in 1763, all right? Two sovereigns the King of England / Great Britain and the King of France. France ceded, not relinquish. The word cede is in there, not word relinquish. France ceded. Now, why isn't, your question to me, Akeem, would be, Abdullah, why isn't the word cede in Article 1 of the definitive peace treaty between United States and Great Britain? Oh, I'll answer that question, Akeem. The reason why the word cede is not in there and the word relinquish is in there, because who are the parties? A sovereign and subjects. Sovereign, King George III, all right? The subjects, all right? Subjects, those are the members of the United States. Those are their subjects. They're not sovereigns. They're not sovereigns. All right, that's. I'm going to be very clear. All right.
All right.
They were born. Let me finish here, please. This is for everybody. This let me flow. Please let me flow. Please let me flow. Just let me flow, bro. You'll get it. Just be patient with me, please. Be patient. They were born as British subjects in the British Dominion on Moorish soil. Their parents born as British subjects on Moorish soil in the British Dominion. Their grandparents born as British subjects on Moorish soil in the British Dominion. Their great-grandparents born as British subjects on Moorish soil in the British Dominion. Their great-great-great-grandparents born as British subjects in England. So British subjects, British subject, British subject, British subject. So let's look at the genealogy. That's why I'm answering. This is how you have to answer it. You have to come from different angles. So now I'm using genealogy. So it's important to look at the genealogy. So you have a sovereign, King George III, and subjects. They are not of equal footing as far as their genealogy is concerned. In the 1763 treaty between the King of France and the King of England, those are two sovereigns. So relinquish and cede. Write this down, y'all. Your homework. Your homework is to look up relinquish and cede. They don't have the same meaning. There's two, all right, one. They're two different words. They don't have the same meaning. They're not interchangeable. All right, Shem.
Yes.
Shem's going to continue. We still want the answer. We still want the answer. Go ahead, Shem.
Yes. Now we deal with pedigree now. Thank you, Professor Abdullah. Status and pedigree, handed down through lineage, kinsmanship. The crown was given at this a queen or a king is called a prince or princess, and a subject is a common. Don't have the same status. This is why every king and queen got the Privy Council, which are the dukes, earl, counts, barons, and marquises. They're the ones that are part of the royal family. So when a decision is made, they have to go for all the heirs to make sure that decision is settled. They agree with that because they have an interest in all the wealth and commerce and economic value which that government is getting from that foreign nation to conquest. Now, if I go get a house, if I get a house, my son is living in a house. My son. I got a worker. There's a difference between my son and a worker, my daughter and a worker, employee. Now, I have a business. And I said, you know what? I'm gonna let you manage the business. But my son, I said, I'm gonna let you inherit the business. That's the difference. I'm gonna let you control on everything. Now, you can relinquish jurisdiction over your house or territory to a people to self-determine among themselves. They affiliate themselves as a private community. You relinquish the political jurisdiction for them to operate. But then you don't see the territory land, the dominion, that you're the only one that was given that. You can't give it to them without the hosting sovereign agreed upon that. Because, you understand what I mean? If you see that territory to them, and there's native Moors or native Aboriginals staying there, and they always occupy that land and that territory as a political body before you can't cede that land. You don't have the power. You have to go before the sovereign that you signed an agreement with, treaty with, to allow you to be there as a conquest power. It's very important. I use the word a son or daughter of a company and an employee of a company. It's different. When you say relinquish and see, it's two different things. If I got sons and children, and I tell my worker that work in the house or me, I'll relinquish this to you right here in the house. That's not ownership. That's not control over my assets, my inherit right, everything I got for my children for inherit claim. No, it doesn't have that. So United States never won a war. Number one, they never won a war. They was aided in the war by France and Spain, which forced Great Britain to sign a treaty with the United States because the war became expensive. And because of the violation of the Triple Treaty Alliance between the European powers, that treaty was violated when the European subjects rose up against the crown, England, Great Britain, the subjects, the rebels. What happened was they went to France in 1770 and signed a treaty with a sovereign power. Then they went to the sovereign Moors and signed, then that be Moors and signed another treaty. So you see that the rebel, the British subjects are going to the friends of the crown. The allies of the crown signed a treaty. That's an act of war. When an ally signed a treaty with an enemy of his ally, that's an act of war. Now, the Great Britain never gave the United States the political, the territory grounds. They only allowed them to have allegiance to their political jurisdiction over their own affairs in that territory. They were ceded to them by the Moors, successor treaties. So I'm gonna bring it, make sure it's clear. They were only allegiance political jurisdiction over themselves in that dominion of the crown of France, Spain. There was only allegiance jurisdiction to govern among themselves, but they were never ceded the territory over longitude, latitude territory of a dominion. This is why the United States Supreme Court case, the Supreme Court say that the sovereign power of conquest belongs to the original principle, which is the crowns. They made it clear. Supreme Court notice, jurisprudence. United States cannot claim to be a sovereign dominion under colonization. They can't. That belongs to the crown, Spain, France, Great Britain, England, Portuguese, Dutch, Sweden, all these powers. That belongs to them. Now, if they on court, guided by jurisprudence and positive law, knew that United States has never ceded any territory. Let me show you what I mean. Abdullah said it plain and clear. Thank you, Professor, because you beat me to the point. That was on my mind. See, when sovereigns see land, when Great Britain ceded land to France, the 1801 treaty, I forgot what year, I'm gonna try to grab it and give it to Abdullah to put it in the link. That land was ceded back over to, by what? A sovereign. That's called dominion. Dominion in a foreign land, given by a hosting sovereign power. Now, Great Britain didn't have a right to cede the land to the United States because it wasn't there to cede to the United States. It belongs to the Moors. So what they did was they relinquished political jurisdiction to them over their own affairs. They can affiliate among themselves, have elections, have a constitution, and run government among themselves, and have a political jurisdiction and operate, have elections among itself. That's a political jurisdiction. Relinquish what? They relinquish to them their own political jurisdiction in that land. That's it. Any more questions?
See
Yeah,
why you can't, see why, no, we got to go to somebody else. We got another hand up. That's it. We got another hand up. Another hand up.
Professor, before the next person goes, I just want to elaborate on what Shem was saying. I want to give everyone a case reference just to confirm what Shem was saying.
Mhm.
Godfrey, I believe it's Godfrey versus New York. To sum it up, this was a case about a soldier that was in the United States Army or Navy, one of the other. Long story short, this soldier had ended up killing one of his subordinate soldiers, and New York State was trying to prosecute him. And his claim was, "I'm in the military. The jurisdiction is federal, so you got to bring me to a federal jurisdiction." The end result was that I believe that New York ended up prosecuting him, and I think he was executed. Back then, I guess that was the policy back then, but he was executed. Nonetheless, the purpose of me saying this is because the judge's ruling on this is because it was basically the premise of his complaint. The defendant was making a claim. Godfrey say, "I'm sorry, Amanda." That was the no. I believe
I'm
that's
sorry,
the right case.
I posted the wrong one. I'm sorry.
Oh, okay. All right, yeah. So that case, Godfrey versus New York, it was held by the Supreme Court that the judge made it clear that because the issue was the jurisdictional boundaries, the judge made it clear that pursuant to the treaty, and he referenced the definitive treaty of 1783 between the United States and Great Britain, and he made it clear that that he didn't see any language where Great Britain had ceded any land over to the United States.
Absolutely.
Yeah.
Thank you for that, Michael. Thank you. See, this is what I'm saying. This is what I'm talking about. This is evidence of study. This is what I'm talking about. This is a perfect example. This is why we're having these classes. We need people. We got to study. We need an educated. We're gonna rise with knowledge. We're gonna rise with knowledge. We can't have empty shells, meaning that people in positions that don't know anything. I've seen that. Trust, that will collapse in 3 seconds. That will collapse in 3 seconds. I apologize.
Did someone else have a question?
Yes. Yes, we have somebody. Ian, your hand was up. Ayan Il, your hand was up. Are you still with us? Who else is on? Ayan Il.
If they don't have their question, I'd like to ask the second part of my question for that same treaty.
All right, go ahead.
Okay. All right. So then in the other section that I was reviewing in the first article, I just wanted some clarity on where it says His Britannic Majesty acknowledges the said United States, and then it goes on to name the 13 states, which were originally colonies, and then it says to be free, sovereign, and independent states. Could you elaborate on that?
You gave a misconception. You gave a misconception, so I have to qualify. I have to.
Okay. No problem.
The misconception that Akeem gave, that's taught in the schools. The misconception that Akeem gave, that millions of people, both Moors and Europeans, are taught. That misconception that Akeem gave is taught in the schools, in all textbooks, in all history textbooks. What Akeem said is taught in all the history textbooks and United States jurisdictional schools to both Moors and Europeans. Akeem said in the colonies, which were originally, what you say, in the states, which were originally colonies. All right, that's a misconception. The states were not originally colonies. Thank you for that, Akeem. Thank you. Because you gave us the opportunity to clarify this. It's very important. So the misconception that's taught in the schools is that the states were originally colonies. Let's go to the charters. New York Charter, the New York Charter. Pennsylvania, William Penn Charter. You have the Georgia, which was a proprietary charter colony. Pennsylvania, proprietary colony. Duke of York, 1662, King Charles II granted his brother. All right, New York colony. All right, Virginia colony by the companies. So that was a company colony. Massachusetts and Connecticut, and Rhode Island, and New Jersey. New Jersey, a proprietary colony, 24 proprietors. Let's go in the charter. So what created the colony? The charter. Now, as I said before, that you have all right. I think the confusion is, we look at land. Like we start, the confusion is that we don't start with the charter. We don't start with the charter. We say, well, the colony, well, that's like some type of landmass. Like we'll point to, well, yeah, that's the colony. Like, so therefore you don't look at the charter. And that's the mistake. You don't look at the charter, you're associating, well, New Jersey was once a colony. And you're looking at land. Like say, New Jersey, you're associating New Jersey with some landmass. And you say, well, New Jersey, it was once a colony, now it's a state. That's where the misconception comes in, where you don't look at the charter. Look at the charter. Where in the treaty, definitive peace treaty between Great Britain and United States, 1783. Great Britain relinquished, but the charter is still under the authority of Great Britain. Let me explain. All of the quote unquote Ivy League schools. Why am I saying quote unquote? Because Ivy League is just a sport league. That's the reason why they're called Ivy League, is because of the NCAA sports league. All right. So that's improper to say Ivy League. I'm only saying Ivy League, but they're not Ivy League. That's just the sports league. They are colleges, universities, and colleges chartered under the crown. So all of the colleges and universities chartered under the crown, all right, using this classified under sports league, Ivy League. Dartmouth versus Woodard. I have to do this. Dartmouth versus Woodard. Dartmouth was chartered under the crown. And that was set up as a trust with 8 trustees. And in the charter granted by the crown, the king of England, what happened, the state, you have the state of Vermont, which is not the colony of Vermont. The state of Vermont bun rushed, literally bun rushed Dartmouth College. They physically removed the 8 trustees that were put in place that was operating under the charter granted by the Crown. They moved them and put in 18 trustees. That went to court. That's called Dartmouth versus Woodard. Let's go to another case. Society versus, I'm gonna make this tie. Society versus New Haven. Society versus New Haven, 1823. The attorney, as taught in schools, yeah. See, Great Britain lost the war. You know, that's taught in the schools. It's taught in the schools. Yeah, Great Britain, it's taught to the attorney that defended that Great Britain lost the war. Yeah. See, no, so there's nothing, you know, anything that was chartered under the Crown doesn't exist anymore. That's all gone. Any institutions, any colleges, any debts, nothing. No. The Revolutionary War extinguished. The Revolutionary War extinguished all debts, extinguished all charters, extinguished. Great Britain's no more. Great Britain's no more here. Great Britain has no authority, nothing here no more. That's taught in the schools. That's taught in the schools. The attorney had that mentality. The defense attorney in Society versus New Haven, 1823, was operating on that false premise that's taught in the schools. Defense brought that argument that the Revolutionary War extinguished pre-Revolutionary War contracts and agreements. That was the defense made that position all throughout. What did the United States Supreme Court rule make? That the Revolutionary War did not extinguish pre-Revolutionary War contracts. Once again, misconceptions. The public's taught one thing, or indoctrinated to believe one thing. But the Supreme Court justices know better. This is why we have to study, because we got to understand what's the real deal. What's the real deal, McCoy? All right, did I make my point clear?
Yes, your point is
Yeah.
clear. I was just trying to see if you could answer that question.
Yeah, I bet, bring it on, brother. Bring it on.
Okay. So his Britannic
No, I'm saying you already answered it. I thought I answered it. You already asked. So we got any other questions?
you kind of went off on a tangent on the colonial.
No, I didn't go. No, stop you there. I didn't go off on a tangent. Hold on. Let me stop. All right. So there's something missing there. Because you said I went off on a tangent. I did not go off on a tangent. All right. I did not go off on a tangent. What I did was, all right, hear me out, y'all, please. This is for everybody. When you read Society versus New Haven, 1823, please put it in the chat, y'all. You would see in Society versus New Haven that there are other cases that are presented there. I didn't go off on a tangent. I use other cases. I use cases to make my point, as that is the case in Society versus New Haven, Dartmouth versus Woodard, and what Mike did when he brought up the New York case, Godfrey versus New York, is that Mike brought in a case to support. That's not going off on a tangent. We must be able to do that. You see that in the 1952 case between France in the United States. They're not going off on a tangent. They're bringing other cases, other treaties in that are relevant to make the support. That's not going off the, so there's something that's missing there where the connection was not seen. All right.
I'll tell you where the connection was.
Let me finish. Tell you what, I'm gonna put it on myself. I must do better. I'm not gonna put it on Akeem. Akeem said I went off on a tangent. Then that means I got to do better. I have to do better. So what I'll do to do better is I will listen to this section. I will listen to this section this week and see why Akeem said I went off on a tangent. I'm gonna put it on myself. I'm gonna be like Jalen Hurts. I'm gonna be like Jalen Hurts, the starting quarterback of the Philadelphia Eagles. I'm gonna take it and I'm gonna do better. All right? Because about making it, all right. So he said I went off on a tangent. I'm gonna leave it at that. Then I'm gonna look at it, all right, and I'll do better.
Right, I just wanted clarity on this question. That's all. I mean, I didn't get a chance to ask it. We kind of got caught up with my statement about 13 colonies and so forth, that statement. So I just wanted to kind of finish the question I was trying to ask. When it says in the definitive Treaty of Peace, Article 1, His Britannic Majesty acknowledges said United States. And then it says to be free, sovereign, and independent states. I just kind of wanted to see why he would use the term sovereign and independent states if that's clearly not the case.
Okay, let me deal with that. See, you have to understand, there was a war. Great Britain never lost a war. Being that, see, you go back to the peace treaty between France, Great Britain, United European powers. That treaty became broken when France and Spain declared war on Great Britain. That's a violation of that treaty to support the subjects. Now, it's very important. When the rebels, the British subjects rose up and formed their own society, their own community, political organization, self-determined among themselves, they went to France and sovereign. They also went to Leninatic Moors. So therefore, by going to two sovereign powers, they was acknowledged as taken as allies, and they given amnesty, friendship with the two sovereign powers. Now, by doing that, Great Britain acknowledged them as being, because of what? Because, see, on the land, you got to understand, in the land, France, the Moors was a sovereign in their own land. France was an occupied sovereign. These two sovereign powers acknowledged the Congress that was set up by the Lord Proprietors. Matter of fact, let's go back. The war started because the Congress and the British subjects rose up against the Lord Proprietors. When that happened, France had to come in and protect the Lord Proprietors, who was over the colony, lords over the colony, masters over the colonies. So they had to step in. The fight was that the Congress that was ordained, commissioned by the Lord Proprietors, and the Commons of the land or the British subjects want to self-determine among themselves. They want the elections, their own judges, their own Congress, their own judges, their own executive. They want to stay on their own political affairs. That's why there was called states. A state is a political organization of people right to self-determine. That's all the Crown allowed. The Crown only allowed them the right to self-determine among themselves as a political organization. Self-determine to come together as a people. They're still British subjects, but they were allowed by being allowed to do that among themselves, self-determine, like their own officials, and determine among themselves how the political jurisdiction will be operate. That's automatically giving them they act as a sovereign. That's why the Crown acknowledged them as a sovereign. Why? Because they gave them a right. What you mean? They was given a right by other sovereigns, first of all, to delegate and among themselves as a Congress, as a body government, political body. Once that was acknowledged by two allies of the crown also acknowledged their right to self-determine among themselves. That right was granted to them. They ain't taken by force. It was granted to them to self-determine among themselves.
It's not inherited. It's not inherited. It's not.
That's not inherited. That's right. Absolutely. That's right. It's not inherited. Meaning that it had to be acknowledged by the ruling crown, ruling government. So when the crown made that statement, they only acknowledged them, Akeem, their right to self-determine among themselves, to make their own decisions, to have their own elections without any interference of the crown or the Lord proprietors. Because under the old charters, on the old colony charter, the Lord proprietor was the one elected the Congress, elected the judges. And as a matter of fact, the Lord proprietor will operate as the governors and let the governors commission. That was in the power of the Lord proprietors. They wanted to self-determine among themselves. So by granting them that, allowed them to do it, they consider the sovereign. Now, what do you mean a sovereign? They make their own laws. They self-determine among themselves. They have their own elections. That's a sovereign. A sovereign has their own election, has their own community, and is self-determined among themselves. There was not a inherent power when the Abdullah said when the grandmothers, grandfathers, mothers, and fathers came off a ship. They didn't have that self-determined right. There was nothing but employees, workers.
And Lord Shem, if I may expound further on what you and Abdullah was teaching Akeem, the evidence to that is this. The language, I would agree, is a bit trickery if one doesn't understand the history based on sequence of events. Now, with that said, that treaty was enacted and ratified between Great Britain and the United States. But then now, that was 17, now, listen, follow the timeline, this is for the class. But now in 1814, there was another war breakout, which had to bring forth another treaty, the Treaty of Ghent of 1814. Now, that was another treaty that had to go back, that had to be created between Great Britain and the United States because the peace was breached as a result of the definitive treaty. That's when they burnt the White House down, and they had to restore. Now the language is Indians in that, but we know that Indian is a Moor by consequentity in the political status of an Indian, aka British national. But that treaty, okay, was a result of what? United States infringing, British subjects infringing and trespassing on Moorish lands. So that was the cause of that breakout. So what I'm saying is that obviously there were certain lands surveying, latitude, longitude, that was, obviously incorporated in the actual treaty, definitive treaty, but that was breached. So so it was for them to have their own, the sovereign, I guess that the language is convoluted and it wasn't given enough clarity in the actual article of the treaty to where one would just have a straight knowledge of, okay, hey, they're sovereigns or not. Now, like I said, we use the case precedents such as Godfrey versus New York. The Supreme Court justice clearly made it clear that there was no conveyance or ceding of land ever evidenced in the Treaty of Paris between the United States and Great Britain. So therefore, they're leaseholders to their own mother, the crown. They remain British subjects. So they only had the right, like Shem said, they had the right to self-determine. So, like I said, and that wasn't the case, right? That wasn't the case because that, like I said, that war, the Treaty of Ghent Treaty of 1814, was Great Britain on behalf of the United States infringing and trespassing on the Indian territory, on Indian lands. So yeah, so they I don't think if they gave them the right to sovereign supreme, so I don't think they would have ever intervened in that matter because they were still dealing with the natives to the land. Obviously, the language is Indian in there, but that Indian is convoluted within itself, as we know. Mr. Noma.
The reason why I'm allowing this to go on is because of the 100 years of misconception. All right.
Yes. That was great, Michael. That was good, Council Mike.
Because I'm allowing this to go on like this, because this is really good, is because of the misconception of what United States is. So we have to, take our time. So I saw the opportunity with Akeem's question to go to let Mike to expand, myself and Shem, because I know others are here. This will go out to many other people. We must put the time in and to clarify what the United States is because of the over 100 years of misconception that's out there. All right, I taught misconceptions for 25 years to thousands of people. I cry at night. I'm serious. I think I'm dead serious. I'm very passionate about this. I'm very passionate. Very passionate. Very passionate. And that passion is the love that I have for our people. I don't apologize for my passion. I'll never do that.
Have any more questions for Shem? He has about, what, 10 minutes, 11 minutes?
We'll continue. We'll definitely will continue. In fact, actually in 2 weeks, when the next class is in the next class, once again, we will no longer go weekly. Well, it'll be the second and fourth Wednesday of the month. The second and fourth Wednesday of the month. Make that a note. Let other people know. We want to make sure this is on the video. We'll put out a flyer. We're going to put out a flyer. All right. Brother Noel's going to do the flyer for us. All right. Every second and fourth Wednesday of the month. Same time, 7 p.m., 10 p.m. Eastern Standard Time. All right. We will no longer go weekly. We must, I can't overwork Terrence. All right. So we got enough content. This is the 6th class, part 5, class 6. So we have enough content on there, and we'll be going every second and fourth Wednesday of the month. All right, you already know we also have Moroccan Post on Crumb TV every second and fourth Sunday of the month from 6 p.m. to 8 p.m. Eastern Standard Time. All right, and then as we'll be doing my book when Moors and Macy Part 2 comes out. I'll be doing my book tour all over the country and different platforms. All right, so
I want to say something before I leave off, so everybody understand. The 1744 Lancaster Treaty make it clear that anyone Indian is a Moorish subject does not have power to enter into any treaty. Why, Shem? Because our ancestors made decisions years ago, hundreds of years ago, that they were capable of making into any treaty. Why? Because they was captured. They first of all, they called Indian and British to sign treaties with France, Great Britain, and England. They was already under capture. They was already under conquest of their own relatives. Let me say, their kinsmen. Their own kinsmen held under servitude. Yes, that's true. 1744 treaty makes it clear that they captured certain kinsmen were captured and put in conquest by their own kinsmanship. Therefore, by being in conquest, they did not have authority to sign any treaties or cede land to any foreign power. Read the Lancaster Treaty. It makes it clear. Our delegate Moore sat down with Great Britain representatives and made it clear that any Moor called under the title Indian sign any treaties with any foreign powers. The treaties are not, they have authority to do it. See, what happened is we have to use our jurisprudence of our ancestors, our customs. The English Moors made it clear that anyone under de facto denaturalized title for servitude did not have for under us. Anybody that put a servitude on their own in Morocco by any other Moroccan did not have authority to sign any treaties because they were subjects that need approval of that government that had them in conquest. So a lot of treaties the United States signed into are de facto. How do they become de facto? When a claim is made into the World Court that they did not have authority to even enter into treaties with who? We talk about conquest. What were the Moors first put in conquest? Not by Europeans. Let's get it straight. The Moors put in conquest by Moors. Yes, we got to tell the truth. They was already under conquest and put in servitude. Therefore, when they put on that status, they could not enter any agreements unless the sovereign power that conquered them allowed them to do that, got consent. See, we don't talk about this. This is something very deep. We got to go to these concepts. Nobody never touches water. We got to go deep under the water now to the real truth now.
And moreover, Lord Shem, I just want to give if I may, Professor, I want to just piggyback on that and give people more contemporary evidence as proof of claim. Class, in the 1952 case, France versus United States, okay? This is going to show, right? This is where Professor's specialty comes into play, breaking down and analyzing the language and what's actually, as opposed to what's actually real and which can be proven. In the 1952 case, France versus United States, right? I'm gonna make a long story short. In that case, to sum up that case, I'm gonna give a brief synopsis. That case was dealing with tax exemptions and tax immunities in the French zone of Morocco, right? United States was making a claim that they was entitled to a tax exemption, and they relied heavily on the 1786 treaty that was reconvened in 1836, the Treaty of Peace and Friendship between the Sultan of Morocco and the United States. And they came under Article, I believe, 14, which was the most favorable nations clause, which granted the United States on the same footing as well as the European nations that was already here by treaty.
Was that Article 14 of
case,
18? Oh no, Article 14 of 1836 treaty.
Yes, Article 14. It was the most favorable nation. Now listen, because we're gonna clear up now the conversation in regard to what the 1783 treaty expressed as opposed to what's real. They sovereigns, and that's what we taught, right? That's the alleged claim that they sovereigns. Now, in that 1952 case in the World Court, okay. Now let's separate the jurisdiction here. Domestically, which means right now backyard, it's propagated and perpetuated that the United States are sovereign. To the world, in the international arena, it was determined in that case that they was not entitled to any tax immunities or tax exemptions. In fact, now listen, because and Akeem, I'm with you, brother, because we go back and forth with this stuff. But this is why, you know, saying my analyzing and reading thoroughly really comes to, you know, proper conclusions. In that case, the International Court of Justices had determined that no, you don't have most favorable nation status pursuant to the treaty. Now, the World Court and Great Britain and France debunked what the sovereign of the land granted them pursuant to a treaty. Okay, where that authority come from if they're not subjects, if they don't have to listen to their mother, one. Number two, it was determined under the 1856 treaty, because this, listen, this is the claim class. They said, the rebellious children said, but under Article 4 of the 1856 General Treaty between Great Britain and Morocco, we as British, because we're British nationals, British subjects, we get a tax exemption. The court ruled, this is not true. You don't not entitled to the tax exemption. You're not, because you guys wasn't here first and you're our subjects. That's why. So whereas Article 1 of the 1783 definitive treaty, which so-called granted the United States their sovereignty, okay, 1783, in 1952, it was determined that, while here in Morocco, you were subjected to import-export taxes and excise taxes. Now, if they sovereign, how come Great Britain and France is telling them that they got to pay that? Because they're not sovereign. They're their subjects. And even that ruling was following a custom. A custom of what? A custom and tradition of you got to follow the acts, bylaws, okay, and rituals of your foremothers and forefathers. So it's like when mom and daddy tell you it's time to go to bed, mom and dad tell you to eat dinner, you got to go eat dinner. Mom and dad said, you're going to be over here in Morocco, in this land. We have treaties here that existed before y'all came here with the native Moors. So if you're going to be here, you're going to be here and you're going to follow these rules over here while you're here, or you're going to get out. So I digress. Everyone read that case, rights of American nationals in Morocco, 1952 case, France versus United States. And it was determined in that it seems very unlikely that this.
Add there that there are three types of treaties that were used. Three types of treaties that were in the 1952 case between France and United States, International Court of Justice. Three
Right,
types
right. It
of
was
treaties
it was the
that
three.
used
They
to
used 10 bilateral
to
treaties
determine.
from the 15th century up until the
Let me-
19th century.
let's back up though. Let me finish it. There's three
Okay.
types of treaties that were used to determine
Mhm.
the extent of United States consular jurisdiction in Morocco.
Right.
Right? And the first type of treaties were the primary treaties between the bilateral treaties between Morocco and these 10 European states from 1631 to 1892. The second type of treaties that were used to determine the extent of United States consular jurisdiction in Morocco was two multilateral treaties called conventions, the Act of Algeciras, 1906, and the Act to Protect Morocco, 1880. And the third type of treaty was the Feds Treaty in 1912. So
Right.
And Michael mentioned in the 1836 treaty, I think it's Article 14 or Article 24.
The Sultan granted them most favored nation status,
based on
what the Sultan gave them. But the World Court,
based on what the Sultan had given the other European powers.
Yes,
So
yes,
they were
yes.
giving
exactly. But the World Court, at the request of France and Great Britain, okay, because here's the deal. This is how you go to show you're not sovereign. France and Great Britain, United States didn't even notice. It came out in that court in 1937, Franco-Great Britain Convention in 1937. France and Great Britain agreed that Article 4, Article 3, various articles of the 1856 treaty, which is the superseding treaty, okay, dealing with Moors in Morocco, right? It supersedes the Treaty of Peace and Friendship. It was ruled that in 1937, France and Great Britain agreed in the Franco-British Convention, they agreed that they was going to actually abrogate a few treaties from the 1856 General Treaty between Great Britain and Morocco as it pertains to British subjects, right? And the United States didn't know that. So when they was making claims, it came out, all the paperwork and evidence came out that, okay, cool. So if they sovereign, France and Great Britain is sitting there making pacts and making agreements on behalf of the United States without their delegation of authority. And they can do that because they're there by contract under agreement of Great Britain and France and Spain in each's political zone. For example, like Florida is a Spanish zone, and in other parts is British. Louisiana territory is a French zone. Obviously, the 13 colonies, those are British zones. So if that language, and Akeem, I know where you're going, but and I know because we talked about that issue that we was dealing with, but it's the reality of it is that Professor says it all the time, all jurists aren't the same. The fact of the matter is that a lot of esquires and even judges have been domesticated. They've been domesticated. They haven't gone past anything other than their state statutes and municipal laws. They haven't gone past that. And it's evident of that matter that we're dealing with right now. They're dumb, because we got all the evidence to tell us this fool is grossly incompetent. And that's the problem. The problem is we got to school them, and they got 6-figure salaries. They got pensions. Their husbands and wives is living the emolument, and they're highly, grossly incompetent in international law, which governs domestic law.
Now, let me say this. And I said this to Michael, Shem, Akeem, and Terrence a few months back. I said that our knowledge base, as we increase our knowledge base, then they would have to in turn step up. We are going to force them, by our increasing our knowledge base and our national political unity, we're going to force them to step up. They got to bring forth their best jurists as we're teaching, because see the level of knowledge we're presenting. Michael is right. As I said before, all jurists are not equal. Because what I mean by that, you have jurists who have knowledge on ancient world culture and ancient world history. For example, Amanda, you want to put this in the chat? Amanda, that article, the history of equity, the history of equity jurisprudence, the history of equity jurisprudence. Amanda, if you can put that in the chat for everybody. In there, the history of equity jurisprudence. The author starts with the etymology of the word equity. Then he goes into the Code of Hammurabi, but mentions that the Code of Hammurabi is derived, goes further back to Chaldean Egypt.
Yep. That's right.
So
That's
the
right.
point I'm making, the point I'm making, when I say all jurists are not equal, this jurist went back to ancient history, ancient jurisprudence. This jurist, the nature of equity jurisprudence, it's called The Nature of Equity Jurisprudence, that's the title of the article. This jurist took equity, took the principle of equity back several thousand years. And he showed in the article through periods of centuries how the principle of equity jurisprudence has been watered down over the period of centuries. As I said, all jurists aren't made equal. As we increase our knowledge on ancient jurisprudence, we're going to force their hand. We must rise in knowledge, my brothers and sisters. We cannot have empty shells. We cannot have empty shells. This is why we're having these classes, why I make this available for, made it free so people can share it. Please share it, post it. This will be available on tomorrow. This will be available tomorrow on the Moroccan Post Media YouTube page, and I'll send it out as well. All right. Shem, you got any departing words? Okay, how long can you stay with us, Shem?
About 5 more minutes.
All right.
Well,
Just give us some departing words.
Yes. The next class, we're going to show you how the international law is set up.
No, we're going to finish up. No, the next class, we're going to finish up. We didn't finish up.
Okay.
So next class, we're going to finish up, what we already had outlined for today. All right, that's going to be the next. So let's do that. Let's finish up the next class. Let's finish up what we already have outlined. We're not done. We actually have 3 more documents. The consular notification manual, and there was other 2 more. So let's finish that up next time. But because I want you here, all right, because since you have to leave, we can't, we won't continue with that. All right. So I want you here so that you can be able to to assist us in breaking down these articles and these different manuals. All right.
My final thought is that one can only go to the land, earth. When you want something, you plant a seed. You got to go to the earth and plant the seed, make it big. Then you got to depend on the cosmos, the heavens, to give you what you need. That's the world, give you water, mist, dew, the sunlight, the moon cycles. So let's go back about the colonies. So we make sure we're clear. The colonies are charters given to Lord proprietors. They are chartered territory, longitude, latitude, dealing with land, political control over land. Now, the states are the people, the British subjects, some French, some Spanish, living among themselves, was granted the right to self-determine among themselves and have elections, elect their own officials. That is a form of sovereignty, means self-determine itself. The rights are not inherent. The rights have to be granted to them from a subject status to a certain standing among themselves. They have a right to stand among themselves and make self-determined among themselves. That wasn't an inherent right for a British subject or a French subject or a Spanish subject. That wasn't an inherent right. So when you say state, that means now once they had a right to self-determine, they was able to create a political organization the rule among itself. I mean, not every play a political net over the land that was ceded to the occupying sovereigns, which is called Great Britain, conquest sovereigns, Great Britain, France, Spain, Portuguese. This is why it's clear in the Act of Algiers, it said that United States is forbidden. I want you to hear this. The United States is forbidden to make any decisions in European affairs. That's very important. That's in the Act of Algiers. They are forbidden. Listen to the word.
Regarding Morocco. Regarding Morocco. Regarding Morocco.
Right, Act of Algiers. No, this is the Act of Algiers, which says the United States is forbidden to make any decisions in European affairs. So when the conquest sovereigns in the land of Morocco are coming together to self-determine a principle on their dominion, the United States is forbidden. Once the United States is forbidden, the Supreme Court, she said in Morocco, that means the Supreme Court can hear nothing dealing with them more. They're forbidden. Once the government is forbidden, the courts, the agency, everything that exists under them is forbidden to do anything. So when you hear an act signed, and by the way, I'm gonna say this, I'm gonna refresh to everybody's mind. Every nation signed the Act of Algiers. Italians, Russian, all the Persian, all of them signed the act. The Pope, the Holy See. See, we need a Moorish government so we can do what? We can reach out with diplomatic channels to that government and say that, hey, listen, based on this act you signed, we got to write. See, this is what I say. Moors don't need a United States passport. Moors need their own. Moors can get their own passport. All it needs is software and the finance created. Then they do a proclamation from the executive office of the Moorish government and send it to their foreign nations and sign the act or treaty and say, these are our passports. Based on the act, we have a right to come to your port based on a treaty or an act. Now, once that happens, we give our own passport. We're not retarded. Every nation in the world getting their own. Why does I go to the United States and get a United States passport visa? Why? We're sovereign, right? Morocco's a sovereign.
Shem, no, what the issue has been, Shem, you're right. We're not stupid. We're not idiots. We're not retarded. Because of the 100-year of misconception. It's because, all right, there's been over 100 years of misconceptions. We are highly intelligent. We're not stupid. You're right. We're not stupid. We're not idiots. We're not dumb. We've been taught misconceptions by conscious Moors. We've been taught misconceptions by conscious Moors. Because of that, 25 years, I raised my hand on that. So that's where the issue is. So and when we were having the classes, you know, we had over 100 students. The first class, April 2020. Second class was June, July, whatever, 2020. Over 100 so students. And what we were dealing with in the classes was misconceptions. When we were even talking about, and then students were gradually, over the period of 12 weeks, gradually developed, all right? And as we were talking about the facilitation of national unity, because Moors have been introduced to survival, short-term plan, survival, case-by-case, survival, short-term. And we were talking national political unity on how to facilitate that. And we were butting heads, you know, because their foot hurts now. Their foot hurt. Somebody step on their foot hurt now. They want now. All right. So it took some time. It took time, and I see the growth. I see the growth, and you and I, you know, though I've known you for 20 years, and I reconnected with you, and for the first time began working with you, 3.5 years ago. And we see the growth. With people now seeing the value, importance of national political unity. I told you when we stand out by your mother's house in April 2019 that it was going to take time.
Yep.
It was going to take time because of the 100 years of misconception. We just got to stick with it. Stick with it. You start seeing it now, Shem. People are starting developing.
Yep,
It's going to
absolutely.
take time. We getting there, bro. We just got to. It's going to take time.
Yep.
You're right.
Absolutely.
We're not stupid. We're not idiots. We're not dumb because of the 100 years of misconception. That's what we have to break through. All right. I want to
Yes.
thank you, brother Shem.
Yes, thank you. I
Tip
see
my
y'all later
prayers
on.
to you. I'll wrap my turban to you, brother. Thank you.
Yes.
Thank you, brother Shem.
You, Shem.
Yes. Yes, have a nice one.
Peace and be safe.
Love, peace and love.
All right, peace and love.
Peace and love. Peace and love, Sean.
All right.
Terrence, we're going to go to the United. We're going to go to the what's the name? We're going to go to the United States Counter Memorial. Let's go to United States Counter Memorial, and we will continue. We will continue consular notification on the second Wednesday of next month. The second Wednesday of next month, we will continue with consular notification. Right? We're going to go right to the. We're going to continue with the United States Counter Memorial. Let me explain for those who have not been with us. This United States Counter Memorial is part of the 1952 case between France and United States. The case summary, not the case. The case summary is about 40 pages long. That's called a case summary. The case involves France's memorial, which initiates the case, United States Counter Memorial, which the United States had 6 months to respond. That's called a counter memorial in international law, and other motion pleadings. All right. That's part of the case. That's part of the case. What you see, if you were to Google, France versus United States, 1952 case, you'll see the case summary. And there's also where you can have, there also what's also available online are the actual case, which that counter memorial. Now this United States counter memorial to France's memorial is 600 pages long. I combed through it back in 2000, spring of 2020. And I took 15 pages out of that 600-page counter memorial because, of course, I can't teach from a 600-page document. I mean, as far as if you're talking about doing a class. So what I did was I took out the United States jurists, and doing this extensive research, which I've done for over 20 years, has the compensatory extraterritorial consular jurisdiction clauses from various treaties from 1600s to 1800s. All right. So this is what we've been reading for the past 2 classes. Amanda and Viserius has been reading the excerpts of various clauses, compensatory, or it was called compensatory. Before it was called extraterritoriality, it was called compensatory. So the compensatory started being used less, and extraterritoriality began to use more. Let me explain. There's a difference between compensatory / extraterritorial consular jurisdiction and consular jurisdiction. Compensatory / extraterritorial consular jurisdiction is whereby in the treaty, a consul has authority over jurisdiction over criminal and civil matters. But in consular jurisdiction, it's only civil. So do not interchange extraterritorial consular jurisdiction and consular jurisdiction. Do not interchange them as though they have the same meaning. That is a mistake. All right, but once again, compensatory was once used and compensatory was substituted with extraterritoriality. So these are the clauses that we've been reading. And why is this important? Because in those clauses, you will bring it up, Terrence. Terrence, you have it. You have the
Yeah, this is it here.
I say, all right. So, all
I'm
right,
just
so
trying to
in
figure out
those
where we
clauses,
ended up, or where do you want to start?
yeah, I don't know where either. So in those clauses, you'll see with explicit language that only the consul, it'd be a Danish consul, French consul, Dutch consul, only a consul that has jurisdiction. It makes it very clear as to who has the jurisdiction. When a Dane is the defendant, a Danish consul only, the adverb only is used. Because only is used. Only a Danish consul. So I wanted to take the opportunity to share this. I sent this out to about 50 people already. If you would like to have this 15-page excerpt of the 600-page United States Counter Memorial, text your name, put your name and email in the chat. I'll send it out tomorrow. I've already sent it out to the others who are on here, but we got about 10 new people on tonight. So put your name and email in the chat, and I'll send it out to you tomorrow. This is just these 15-page excerpt of the 600-page United States Counter Memorial to Francis Counter Memorial to Francis Memorial in the 1952 case in the International Court of Justice. All right, so I just want to let you know, so those who are with us, all right, as this will continue to go out and be shared, all right, because it's very important that we take our time, that we articulate, that we're clear as to, and that we're not rushing, so like I said before, that I thought it was needed to address, with great clarity, Akeem, because I know Akeem is not the only one. Trust me, he's not the only one. Trust me, he's not the only one. Because we had to be very clear on what the United States is. And to explain the United States, you have to explain by history. You don't go to that's how you explain the United States. You got to explain by history. And that's what we did. All right, so Amanda, do you remember, or Vice Series, you remember where we left off? DuPont, you don't have DuPont, I sent it to you. Guess you don't have it? I'll send it again. Do you remember where we left off? There's a list of about 15 so books that's in one of the paragraphs.
That's where I think we left off.
That's where we left. Right here?
I believe so. At
Yeah,
the
show
end
that
of
again. So yeah, so they're right there.
that
So
one.
let's show. I want to show that again. I at least want to show that again. The books. These are a list of books. These are a list of books on compensatory extraterritorial consular jurisdiction. Some are in French. All right. So these are to show that list of books. All right. So this is like I said, a United States jurist put this together. Because this is a 600-page document, but I said this is just 15 pages of that. So as I said, all jurists aren't made equal. So this jurist has done the research that I've done, for a period of 20 years. All right. And Shem has provided a lot of clarity for me, and looking and analyzing treaties that I've had since 1998. I have the treaties that I have listed in Moors and Masonry, Part 1. I've had them since the spring of 1998. But I was looking at them as from a historical perspective to show our Moorish power. And what Shem did for me was to have me look at them, not only from a historical perspective, but see the law perspective in it. And because my thought was that those treaties were not even enforceable today. I didn't, so I was like, wow, so that opened up. So where was I for all those years? Because I've had those treaties since 1998, and you see in Moors and Masonry Part 1 that I referenced the excerpts of various treaties, but only to show our Moorish power. But now, because of my knowledge base has grown in international law and treaty studies, that in Moors and Masonry Part 2, I show how these treaties can be used. Now, how can these treaties be used, Abdullah? All right. One would ask me. In 1968, this is why I say that on the side, see what I do, I make references. All right. I'm making them, so I'm showing that I don't go off the tangent, that I'm not going off the tangent. I'm making a reference, all right, to make my point. The 1968, in the International Law Commission, United Nations General Assembly on the Law of Secession, the Rights and Duties of States. The representative the representative Salon had challenged the International Law Commission of the United Nations General Assembly of the Law of Secession on the Rights and Duties of States, that Salon was a new state. The representative challenged the International Law Commission's claim that Salon was a new state. The representative of Salon referenced that 19th century, which is 1800s, Salon's diplomatic and treaty relations with other nations, showing that Salon was not a new state, that Salon should re-enter the international community as an old and original state, right? So I said, oh, that's a reference we can use to make our reversion to sovereignty claim, that the Moroccan Empire is not a new state. The Moroccan Empire is a old and original state. Also, in 1952 case, see what I'm doing? Let's hear me out. Let's hear my flow, y'all. Let's hear my flow. The 1952 case between France and the United States. There were 3 types of treaties. I said this earlier, but I'm making this point here. 3 types of treaties that were used to determine the extent of United States consular jurisdiction in Morocco. The first type of treaties, the primary type of treaties, was the Moorish bilateral treaties between with France, Spain, Great Britain, Sardinia, Denmark, Portugal, Spain, the Netherlands, United States from 1631 to 1892. So when I saw that, I said, ooh, those treaties, France stood on those treaties. France stood on those Moorish bilateral treaties from 1631 to 1892 to make her most favorable nation claim over the United States. So if someone says to you, Abdullah don't know what he's talking about, them treaties are old, they haven't expired. What are you going to use for your evidence? The 1952 case. So you don't say, yes, he does. You don't respond by saying Abdullah does know what he's talking about. That's no. Well, Abdullah doesn't know what he's talking about. Well, according to the 1952 case between France and the United States in the International Court of Justice, there was 3 types of treaties that were used to determine the extent of United States consular jurisdiction in Morocco. Are you aware of that? In fact, are you aware that the first type of treaties were used were the Moorish bilateral treaties with France, Spain, Great Britain, the Netherlands, Sardinia, Denmark, Sweden, between 1631 to 1892. Are you aware of that? That's how you do it. That's how you do it. You see what Michael does? Just hear Michael. Just hear Michael talk. You see, listen to how talk, how we're referencing case after case, treaty after treaty, we're referencing. When you look at the Society versus New Haven cases, when you read these treaty cases, you're going to see the same thing. You're going to see the same logic, same reasoning. We got to raise you up. We have to raise this. We have to raise the level of education. All right, is that where we got left off?
I believe so.
All right, so Amanda, you did read those. The books. So you just wanted to show the list of those books, and then you're going to go right here. All right, go ahead, Amanda. Thank you.
Proof in support of this view is abundant. From the most remote time, there exists evidence establishing the practice of extraterritoriality as a normal and necessary consequence of the principle of personality of law. Thus, as early as 1200 BC, the Phoenicians lived under their own laws in Egypt. See the Law of Nations. In the 6th century BC, the Greeks who were established in the Egyptian city of Naucratis enjoyed an independent administration of justice under their own laws. The Israelites, at least twice in their history, sojourned under capitulations. The Romans, like the Greeks, denied the application of their laws to aliens and required that aliens live under their own national laws as administered by the people. Such was the historical development of the practice of extraterritoriality at the beginning of the 16th century, when the European states began to enter into regular treaty relations with the Mohammedan states. The practice was embodied in those treaties. Treaties concluded with the Ottoman Empire, first by France, 1528 to 1530s, and thereafter by practically all European powers, Great Britain, the Netherlands, Austria, Hungary, Sweden, Italy, Denmark, Russia, Spain, Belgium, Portugal, etc., and with Algiers, Morocco, Tripoli, Tunis, Persia, Muscat, and Zanzibar, Egypt, Ethiopia, etc., provided for extraterritorial jurisdiction ranging from exclusive jurisdiction of the foreign consuls in cases civil and criminal involving their nationals only to jurisdiction in mixed cases, civil and criminal, in which their nationals were defendants. the Mohammedan communities merely continued Great Britain entered into very extensive treaty relations with the sultans of Morocco during the 18th century in the 1700s. Treaties were concluded on January 23rd, 1721, with additional articles dated July 10th, 1729, December 15th, 1734, January 15th, 1750, with additional articles dated February 1st, 1751, July 28th, 1760, with additional articles dated May 24th, 1783, and on April 8th, 1791. Finally, another treaty was concluded just after the turn of the century on June 14th, 1801, with explanatory articles dated January 19th, 1824. With respect to economic rights, freedom of commerce was granted to British traders in one form or another in all these treaties and found its clearest expression in Article 36 of the Treaty of 1791. There shall be an entire freedom, since the controlling principle in the development of capitulation was the principle of personality of law. It is erroneous to analyze the capitulations which developed in Morocco by reference to the principle of territorial sovereignty. It is true that today the principle of jurisdiction based on territoriality has become the more general accepted rule. Equally true is the fact that the system of extraterritoriality has acquired, as a result, an exceptional or anomalous character. But this is solely the result of evolution, and the conclusion cannot be drawn from it that the system of extraterritoriality had an anomalous and exceptional character when it developed in Morocco and other Mohammedan states from the 16th to the 19th centuries. Thus, the historical result, the fact that today the principle of territorial jurisdiction is the rule and principle of the personality of law, and the exception should not be adopted as a general rule of interpretation of capitulations, and the extraterritorial institutions of Morocco should not be analyzed in terms of derogations to the principle of territorial sovereignty. When applied to the case of Morocco, the theory that extraterritorial jurisdiction should be analyzed in terms of derogation from territorial sovereignty leads to conclusions inconsistent with the terms of the treaties, starting from the concept that the exercise of criminal jurisdiction by the foreign consul was a more extensive derogation from territorial sovereignty than the exercise of civil jurisdiction. The French government reaches the conclusion that there existed two states of extraterritorial jurisdiction in Morocco: the stage of consular jurisdiction, in which foreign consul exercised only civil jurisdiction in litigation between his nationals, and the stage of capitulatory system, in which the foreign consul exercised, in addition, criminal jurisdiction over the nationals of his country, as well as jurisdiction in mixed civil cases involving his nationals as defendants and natives as plaintiffs. It may be that in reaching this distinction, the exercise of jurisdiction in mixed civil cases was also considered an unwarranted derogation from territorial sovereignty by the French government. In any case, the point of this argument is that the presence or absence of criminal jurisdiction is a controlling, if not the controlling, criterion of the distinction between consular jurisdiction and capitulatory system. The validity of the distinction can be most readily tested by applying it to the general treaty concluded by Great Britain with Morocco in 1856, which the French government cites as an example of the stage of extraterritorial jurisdiction defined as capitulatory system. In Article 8 of this treaty grants to the consuls of Great Britain jurisdiction to decide both civil and criminal cases arising between British subjects and protégés, and Article 9 grants them jurisdiction to decide both civil and criminal cases arising between Moroccan plaintiffs and British defendants. in all criminal cases and complaints, and in all civil differences, disputes, or causes of Terrence, can you tell me that word? I can't see it. Okay, or causes of litigation, sorry, which may occur between British subjects, the British consul general, consul, vice consul, or consular agent shall be sole judge and arbiter. No governor, Qadi, or Moorish authority shall intermeddle therein, but the subjects of Her Britannic Majesty shall, in all matters of criminal or civil cognizance arising or existing between British subjects exclusively, be amenable to the tribunal of the Consul General, Consul, or other British authority only. All criminal cases and complaints and all civil differences, disputes, or causes of litigation arising between British subjects and subjects of the Moorish government shall be adjourned in the following manner. If the plaintiff be a British subject and the defendant a Moorish subject, the governor of the town or district or the Qadi, according as his case may appertain to those prospective courts, shall alone judge the case, the British subject making his appeal to the governor or Qadi through the British Consul General, Consul, or his deputy, who will have a right to be present in the court during the whole trial of the case. In like manner, if the plaintiff be a Moorish subject and the defendant a British subject, the case shall be referred to the sole judgment and decision of the British Consul General, Consul, Vice Consul, or Consular Agent. The plaintiff shall make his appeal through the Moorish authorities, and the Moorish governor, Qadi, or other officer who may be appointed by them shall be present, if he or they so desire, during the trial and judgment of the case. Should the British or Moorish litigant be dissatisfied with the decision of the General Consul, Consul, Vice Consul, Governor, or Qadi, according as the case may appertain to their respective courts, he shall have a right of appeal to Her Britannic Majesty's Charge d'Affaires and Consul General, or to the Moorish Commissioner for Foreign Affairs, as the case may be. Annex 20. To put it in the phraseology of the French government, this capitulatory system grants to British consuls, in addition to jurisdiction in civil litigation between British nationals, criminal jurisdiction to prosecute British nationals, as well as jurisdiction in mixed civil cases involving British nationals as defendants and Moroccans as plaintiffs. But if the French government is correct in asserting that the capitulatory system granted to Great Britain for the first time in 1856 is distinguishable from consular jurisdiction because it grants to British consuls criminal jurisdiction to prosecute British nationals, it must follow that prior to the capitulatory system established by the Treaty of 1856, British consuls did not have criminal jurisdiction to prosecute British nationals and possessed only jurisdiction in civil cases arising between British nationals. Treaties concluded by Great Britain with Morocco during the 18th century, however, already conferred upon British consular jurisdiction to decide criminal cases arising between British nationals.
Now, so stop there, Amanda. Now, did Amanda read anything about Constitution? Did she read anything about according to such and such Constitution? I mean, this treaty. All right, continue.
Got your point.
Thus, Article 9 of the Treaty of 1721 provided, if any quarrel or dispute shall happen between any Englishman and a Mussulman, by which hurt to either may ensue, the same to be heard before and determined by the Emperor only. And if an Englishman who may be the aggressor shall make his escape, no other Englishman shall suffer upon his account. And if Englishmen shall quarrel to be determined by the English consul, who shall do with them as he pleases. Similarly, Article 9 of the Treaty of 1760 stated, if there shall happen any quarrel or dispute between any Englishmen and any Mussulman, by which any of them may receive detriment, the same shall be heard and determined by the emperor alone. And if any Englishman who shall be the aggressor shall make his escape, in such case no other Englishman shall suffer on his account or in his place. It is also agreed that if any lawsuit, dispute, or difference arises between subjects of His Britannic Majesty, they shall be accommodated by the consul of the nation. Article 13 of the Treaty of 1856 merely stated in more precise and detailed language the civil and criminal jurisdiction in cases arising between British nationals, which had already been granted to British consuls in previous treaties. Thus, it is the grant of civil and criminal jurisdiction in civil cases arising between Moroccan plaintiffs and British defendants contained in Article 9, which distinguishes the Treaty of 1856 from previous treaties. The distinction between consular jurisdiction and capitulatory system, therefore, is unsound. The application of the distinction between consular jurisdiction and capitulatory system to the Spanish Treaty of 1861 leads to the same conclusion. The previous treaties granted to Spanish consuls jurisdiction, both civil and criminal, in cases arising between Spanish nationals.
Let me stop you there. All right, so now you see what I'm talking about? The distinction between capitulatory / extraterritorial consular jurisdiction and consular jurisdiction. See, capitulatory / extraterritorial consular jurisdiction, whereby that nation is now have authority both over civil and criminal matters, but consular jurisdiction is only civil. So that's just one that point is reiterate there. I'll continue.
Article 12 of the Treaty of 1767 provided for the contestations among Spanish nationals, civil as well as criminal, their consul alone shall be competent. Later treaties merely maintained in force the civil and criminal jurisdiction in cases between Spanish nationals already granted in the Treaty of 1767. Thus, Article 10 of the Treaty of 1861 provided the consul general, consuls, vice consuls, or consular agents of Spain shall be the only judges or arbiters in criminal cases, lawsuits, actions at law, or disputes of any kind, civil or criminal, which may arise between Spanish subjects resident in Morocco, and no governor, Qadi, or any other Morocco authority shall interfere in such cases. The later treaties, however, also enlarged this jurisdiction by granting, in addition to Spanish consuls jurisdiction, civil and criminal, in cases. The later treaties, however, also enlarged this jurisdiction by granting, in addition to Spanish consuls, jurisdiction, civil and criminal, in cases arising between Moroccan natives and Spanish defendants. Thus, Article 11 of the Treaty of 1861 provided all actions, criminal cases, lawsuits, litigations, or disputes of any kind, either civil or commercial, which may arise between Spanish and Moroccan subjects, shall be decided in the following manner. If the suitor or plaintiff shall be a Spanish subject of the defendant or accused a Morocco subject, the judge of the case shall be the governor of the city or district, the Qadi, according to the case belongs to the jurisdiction of one or the other. The Spanish subject shall lay his demand before the governor or Qadi by means of the consul general, consul, vice consul, or consular agent of Spain, and they shall have the right to attend the court during the trial. If the plaintiff be a Morocco subject and the accused a Spanish subject, the case shall only be submitted to the cognizance and decision of the consul general, consul, vice consul, or consular agent of Spain. The plaintiff shall present his demand through the Morocco authorities, and the Morocco governor, Qadi, or other official appointed by them may be present if they desire it during the trial and decision of the case. If the Spanish or Morocco plaintiff or litigant shall not comply with the decision of the consul general, consul, vice consul, or consular agent, or with that of the Morocco governor or Qadi, according as the case may belong to the tribune at one or the other, they shall have the right to appeal prospectively to the charge d'affaires of Spain or the Morocco Commissioner of Foreign Affairs. As is the case of the British treaty, it is the grant of civil and criminal jurisdiction in cases arising between Moroccan plaintiffs and Spanish defendants contained in Article 11, which distinguishes the late treaty from previous treaties. Thus, the analysis of the British Treaty of 1856 and the Spanish Treaty of 1861 leads to conclusions which go beyond the refutation of the distinction between consular jurisdiction and capitulatory system. Their history strongly suggests that the normal role of extraterritorial jurisdiction in Morocco before the conclusion of these treaties was jurisdiction of the foreign consul in civil and criminal cases arising between their nationals. A review of the treaties concluded by Morocco during the 17th and 18th centuries confirms this view. Some of these treaties expressly conferred criminal jurisdiction upon the foreign consul in cases arising between his nationals. The American consul has jurisdiction in any disputes arising between American citizens, but the word dispute is not further defined. The French government admits that this jurisdiction extends to civil cases, but argues that it does not include criminal cases. This argument, predicated solely on the distinction between consular jurisdiction and capitulatory system, asserts that criminal jurisdiction is found only in treaties establishing a capitulatory system, such as the British Treaty of 1856 and the Spanish Treaty of 1861. This distinction has been shown to be without any validity. In any event, it is clear that the word dispute at the time of drafting the treaty did not describe exclusively civil cases. One, the same principle applied to the treaties concluded in 1825 with Sardinia and in 1830 with Austria. The privilege of the American consul, it should be noted, was not merely the passive right to be present at the trial, as the French government contends. The same formula was used in a number of other treaties where its meaning was more clearly defined. In the Treaty of 1682 with France, Article 16 provided, any Frenchman who shall hit a Moroccan shall not be punished until said consul has been called to defend the cause of the Frenchman. Similarly, the Treaty of 1767 with France provided in Article 13, if a Frenchman
Hits a Moor,
he shall be judged only in the presence of the consul who shall defend his cause. Article 14 of the Treaty of 1767 with Denmark provided, if there shall arise a difference between a Moor and a Danish national, the emperor or the governor of the place where this happens shall decide it in the presence of the consul, who shall deny his cause as he may. Since at the time the treaty was drafted, dispute described criminal as well as civil cases, the granting of jurisdiction to the American consul in any disputes arising between American citizens granted him criminal as well as civil jurisdiction in such cases. The United States treaty, therefore, like other treaties concluded during this period, merely reflected the general role of extraterritoriality in force in Morocco since the 17th century, which left the administration of justice in all cases arising between foreigners of the same nationality to their consul. The existence of this general rule in the 17th and 18th centuries, as well as the exclusive, no, what is that? The existence of this general rule in the 17th and 18th centuries, as well as the extension of jurisdiction in mixed cases, which obtained in the British Treaty of 1856 and in the Spanish Treaty of 1861, were nothing but the logical and necessary consequences of the principle of personality of law. The Moroccan society of the time was eventually a closed society bound by religious ties and administered under a system of religious law from which the foreigner was necessarily excluded. Proceedings in criminal cases, as in civil cases, were contests between private parties. In the circumstances, the application to foreigners of their national law and the administration of such law in any case arising among themselves by their consul was the normal and necessary solution. Mixed cases, i.e. cases between natives and foreigners, presented a problem, however, since the two laws, instead of functioning side by side and independently from each other, necessarily conflicted. The Moroccan law prevailed in mixed cases until the 19th century, when under the pressure of more extensive intercourse between natives and foreigners, the foreign law and the local law were brought to a position of equality by attributing jurisdiction in mixed cases. So the tribunal of the in mixed cases to the tribunal of the nationality of the defendant, in application of the principle of actor I can't say that word, forum res. The Moroccan courts retained jurisdiction in all cases in which Moroccans were defendants and the foreigners were plaintiffs, while the foreign consul exercised jurisdiction in all cases in which his nationals were defendants and Moroccans were plaintiffs. Morocco, moreover, relinquished jurisdiction in all cases between foreigners and of different nationalities. British Treaty of 1856, Article 14, Spanish Treaty of 1861, Article 16. And jurisdiction in practice was attributed to the consul of the nationality of the defendant. Thus, under the controlling influence of the concept of personality of law, did territorial jurisdiction develop in Morocco from the 16th to the 19th century.
All right, thank you, Amanda, thank you. All right, everyone. So we have, once again, we're gonna be moving to every second and fourth Wednesday of the month, same time, 7 p.m. to 10 p.m. Eastern Standard Time. We will be putting out a flyer. All right, but that's for your FYI. Second, we've been making this announcement for the past month now. So we'll be moving no longer weekly, every second and fourth Wednesday of the month. Please pass the memo. All right, but we'll be putting out a flyer. So letting other people know. This will be available tomorrow. This video will be available tomorrow on the Moroccan Post Media YouTube page. But as you know, I've also sent it out to people. But on Moroccan Post Media YouTube page, this video, this live video recording of this class will be available tomorrow on the Moroccan Post Media YouTube page. Share it, post it on your social media platforms. Also watch it, take notes, ask questions. We'll see y'all in the second Wednesday in October. Second Wednesday in October. Once again, my books, you go to mooresandmasonry.org for Moors and Masonry Part 1, the Masonic Compass Square and the connection and measurement of timekeeping, how our Venus and moon rule, the Illuminati, illumination of the mind, etymology, vocabulary, vocabulary, something that you want, go to mooresandmasonry.org, mooresandmasonry.org. All right. So we also have, for more information on our clarification on what United States is, we have a 3-part series on checkmate. Checkmate part 1, 2, and 3 on the Moroccan Post, on Moroccan Post Media YouTube page. Moroccan Post Media YouTube page, we have checkmate 1, 2, and 3. All right, so that's for further and more detailed lessons on clarifying the what United States is. We go into the treaty of definitive peace treaty between Great Britain and United States, 1783. You know, so that's very detailed lesson. So check out the Moroccan Post Media YouTube page. And once again, we also have the Moorish Body Politic Formation classes, which are 12 classes, which gives you principles on ancient ecclesiastical law principles, the seer and seership, divine law. It's class 6 and 7 of public administration, international law on there yet? Class 6 and 7 of public administration, international law class.
No, we'll have that up this week.
All right, that'll be up this week. Class 6 and 7 of public administration, international law course will be up on the YouTube Moroccan Post Media YouTube page. Shem teaches class 6, and it goes into the ancient principles of ecclesiastical law, the seer and seership principle. I go into the divine law, so we're making that available for everyone. That's just only class 6 and 7 of public administration international course will be available for everyone. All right, thank you again. We'll see y'all on the 2nd Wednesday of October at 7 p.m. Eastern Standard Time, and we will continue with consular notification. I want to thank you for your attentiveness, your questions, thank you for mentally traveling with us. And once again, look at the classes, go to Moroccan Post Media YouTube page, post the classes, share them, look at them. We're looking to raise the level up so we can get this out to tens of thousands of people. Thank you again. Peace, everyone. Once again, this will be available tomorrow. Peace.
Peace and love. Peace and love.
Peace and love, everyone.
Good looking out.
Take care. Thank you again.
Thank you.